influenced by anyone in the manner any other person basically would be influenced. So when that happens, how does society basically respond? When a judge falls short of the expectations of society in terms of those three things that we looked at last week: integrity, independence, impartiality. So when we are judging judges, members, those are the three things against which a judge is to be judged. Those are the three things against which a judge is to be judged. If there is going to be confidence in the justice system, if there is going to be confidence in the justice system, it is imperative, members, it is imperative that indeed the manner in which the justice system operates encourages level of confidence in the general public. However, if the general public can see that there is some level somehow of compromise in the manner the judges conduct themselves when it comes to issues of code of conduct, then there is a very, very, very big problem. It is then when you get to see now members of the public taking the law in their own hands. And when it reaches to a stage when members of the public start taking the law in their own hands, just know that that is the beginning of a destruction to the fabric of society. The justice system, judges play such an important role in maintenance of public confidence in the dispensation of justice. But what will determine that? What will determine that are those three pillars that we looked at last week as provided for in the Judicial Code of Conduct Act of 1999. So I want to bring it back on the screen so that we can then carry on, continue to looking at that, because that is what we started looking at last week. So let's look at the Judicial Code of Conduct Act of 1999. Yeah, let's look at the Judicial Code of Conduct Act 1999. And you shall see what this basically tells us. So we are looking at two legal frameworks when we talk about the Judicial Code of Conduct. We're talking about two legal frameworks. We're talking about the Constitution. And last week, just bear with me 1 minute. I'll just leave my chair for 1 minute. And I'll mute myself for just 1 minute, members. Bear with me. I'll be back just 1 minute, please. All right. Okay, I'm back now, members. So we are looking at the Judicial Code of Conduct Act. So we were saying earlier that there are two legal frameworks when it comes to the manner in which judges ought to be checked. There is a constitution, and in the constitution we looked at Article 143, which basically talks about the manner or the reasons why a judge, or the removal of a judge rather, grounds on which the removal of a judge may be instituted. And then Article 144 tells us about the procedure for the removal of a judge. But we only looked at Article 143, which tells us about the grounds on which a judge may actually be removed, the grounds on which a judge may actually be removed from the bench. We say that of particular importance for us is paragraph C of clause 1 of Article 143, which tells us about gross misconduct. Now, we went through the Constitution to try and establish what really the Constitution has defined gross misconduct to be, and we did not find anything there that the Constitution tells us basically amounts to gross misconduct. We looked at also the interpretation section of the Judicial Code of Conduct Act, and equally we did not find anything there that tells us about gross misconduct. However, the provisions in the Constitution, that is with regard to judges, it didn't tell us. With regard to judges, it didn't tell us, but it defines generally in Article 266. Article 266 gives a general definition of what gross misconduct basically is. So it is a general definition. What is contained in Article 266 is a general definition of what basically amounts to gross misconduct. It is not particularly addressing gross misconduct with regard to judges. It is speaking generally. So that you apply together with the provisions now of the Judicial Code of Conduct Act to ascertain or to establish indeed gross misconduct of a judge. So you are using two pieces of legislation. You are using the Constitution in Article 266 read together with Article 143, and then you are also reading the Judicial Code of Conduct Act, and we shall see the specific sections under that Act of Parliament. Of particular interest, like I said, under article number, excuse me, under article number 143, clause 1, of particular interest for us is clause number, or rather paragraph C, which basically talks about gross misconduct. So a judge shall be judged. Based on his or her conduct. A judge shall be judged based on his or her conduct as is provided for in paragraph C of the Constitution of the Republic of Zambia. Not so much as provided under the paragraphs A, B, and D. Let me just bring them up on the screen. Just bear with me. Let me just bring up the Constitution on the screen. 1 minute. Just 1 minute, members, bear with me. Just want to bring the Constitution of the Republic of Zambia on the screen, so that that is the one that I am sharing. So just bear with me. It's just coming up now. Okay. Excuse me. So we are looking at Article 143. So we are saying we're not so much interested. We're not so much interested in paragraphs A, B, and D. Of course, we can have interest for other reasons or purposes, but for purposes of our discussion, we are not so much interested in paragraphs A, B, and D, because those have nothing to do with misconduct. Remember that the act is code of conduct. The opposite of conduct is misconduct. And therefore, what is this misconduct that one would be said to have acted in line with the provisions of paragraph C, read together, of course, now with the Judicial Code of Conduct Act. So we are not so much interested in paragraphs A, B, and D, but so much with C. So now, if we say misconduct, we say that this is to be read together with the provisions of 266, which talks about definition of terms. So Article 266, members, reads as follows. Article 266 defines the terms. Article 266 of a constitution basically defines the terms. It defines the terms, and this is what it says of gross misconduct. So it tells us, the Constitution tells us that gross misconduct means any one of these. So again, we will need to identify which of these is to be applicable to judges. We will have to identify which of these forms of misconduct is basically applicable to the judges, because it is not just everything that is here that would be applicable to judges. Very, very important point for us to basically take note of. Misconduct or gross misconduct means behavior which brings a public office into disrepute, ridicule, or contempt. Of course, that would apply to judges. Behavior that is prejudicial or inimical to the economy or the security of the state, that also may be applicable to judges. An act of corruption definitely will be applicable to judges. using or lending the prestige of an office to advance the private interests of that person, members of that person's family, or another person. Okay, so when you look at this, you'll see that almost everything, when we read this together with the Judicial Code of Conduct Act, you will see that almost everything here equally applies to judges. But you will see that mainly what is applying to the Judicial Code of Conduct Act is what we have in paragraph D paragraph D of the definition of judicial, or the meaning of judicial, or of gross misconduct rather. Paragraph D of judicial, or of gross misconduct rather. Paragraph D of gross misconduct. You will see that this is the one that especially is applicable to our case, which is about Judicial Code of Conduct. So let's go now to the Act. Let us now go to the Judicial Code of Conduct Act. We were looking at part number 2. We were looking at part number 2 on Friday when we had our last class, and part number 2 basically talks about excuse me, adjudicative responsibilities. So this code of conduct for judges applies to them in the course of executing their adjudicative responsibilities or functions. It applies to them in the course of executing their adjudicative responsibilities or functions. So the starting point, which is what I left you with on Friday, is section number 3. The starting point, which is what I left you with on Friday, is section number 3, independence and impartiality. Independence and impartiality. It says a judicial officer. And who is a judicial officer? A judicial officer is defined here. A judicial officer is defined here as the Chief Justice, the Deputy Chief Justice, a judge, chairman, deputy chairman, registrar, magistrate, justice of a court, or other person having power to hold or exercise the judicial powers of a court. So it is purely speaking of judges. It is not talking about persons working as administrators. It is not talking about persons working as administrators in the judiciary. It is actually talking about people who exercise judicial authority. So it is saying that a judicial officer excuse me, shall uphold the integrity. The integrity, these are the 3 things I mentioned earlier: the integrity, independence, and the impartiality of the judicature in accordance with this constitution, or in accordance with the constitution. Now, when it says in accordance with the constitution, now, that is why I said you need to read the constitution together with the Judicial Code of Conduct. It says in accordance with the constitution, this act or any other law. Now, what does it mean when it says what does it really mean? You know, when it says in accordance with the constitution, what it means, members, is this: What it means is this here. That is what it means. When it says in accordance with the Constitution, what it means is just that, which is what we had looked at earlier as the meaning of gross misconduct. So, as a judge performs his or her adjudicative functions, they ought to ensure that they uphold the integrity of a judiciary. How? Behavior which brings a public office into disrepute, ridicule, or contempt. A judge must not act in a manner that would bring disrepute, ridicule, or contempt. Otherwise, then the integrity of the judiciary is compromised. So now, members, this is very, very important. And the reason why I am saying this is very important is simply because this is what is happening currently. You know, what we are discussing is a contemporary issue. You know, it is not something that is, you know, theoretical. No, these are practical things that are actually happening now. We know of the suspension pending removal of 3 judges. So now, as we learn about those issues that are currently happening with regard to those 3 judges, we must ourselves now, not waiting for the courts. No, you and I, as experts, as you now are becoming in matters of law, you now to start looking, okay, so what did these judges do? Why have they been suspended? Their suspension, does it fall under any one of what is to mean integrity? Because it is not so much about independence. Perhaps it may not be so much about rather impartiality. Perhaps it could be so much about integrity. It could also be about independence. It could also be about impartiality. But you would, as you hear a lot of this information coming out into the public, you will hear that it is so much to do with the issues of upholding the integrity of the judiciary. So now, what does it mean when we speak about upholding the integrity of the institution of the judiciary? And what they did, those 3 judges who are now yet to be tried before the Judicial Code of Conduct, Judicial Complaints Committee. These judges, you know, what they did, does it in fact fall? What these judges did, does it actually fall what is provided for in what is referred to as gross misconduct? Behavior which brings a public office into disrepute, ridicule, or contempt. B, behavior that is prejudicial or inimical to the economy or the security of the state. C, an act of corruption. D, using or lending the prestige of an office to advance the private interests of that person, members of that person's family, or another person. That is what we mean when we talk about integrity. So let us go back now to the act. Let us go back now to the act. So we shall be interchanging. We are going to be interchanging. We look at the provisions of the act. We look at the provisions of the constitution. We look at the provisions of the act and the constitution. And also eventually we shall look at what courts have basically had to decide in instances of this nature. Let us now look at section 3. So a judicial officer shall uphold the integrity, the independence, and impartiality of the judicature in accordance with the Constitution, this act, or any other law. So there are three things, like we've been saying. These are the things that judges are judged on, members. When we speak about when judges are judging others, who is judging the judges? So if we are to judge the judges, we ought to judge them from those three angles. Integrity, what they are doing. Is it really promoting the integrity of a judiciary? In the conduct of their adjudicative functions, are they independent, or is in fact the institution of a judiciary independent? Now, when we talk about independence in the judicature, we are talking about two types of independence. We are talking about institutional independence and also individual independence. We are talking about institutional independence and also individual independence. And then are judges impartial, meaning are judges using their eyes to adjudicate matters, or they are using their ears? Remember, in the first year, we talked about Lady Justice, and we said Lady Justice is blindfolded. The reason why Lady Justice is blindfolded is simply to depict that justice is blind, meaning justice is impartial. So as a judge performs his or her functions, a judge ought to be impartial in the performance of his or her function. Now, it is not always the case that because there is a provision for impartiality, a judge therefore shall act impartially. No, there would therefore be need for further provisions of law which shall guide the manner in which a judge ought to conduct him or herself, where it becomes apparent, where it becomes clear that perhaps the impartiality of this judge may be compromised, and the judge may be not declaring his or her interest that in this matter, one of the parties to the matter perhaps may be directly linked with them, either that they have a benefit to the outcome of the matter, or that maybe one of the parties to the matter may be so closely related to them that chances of them having to arrive at justice in a manner that will appear impartial may be compromised. So the law, which is the same law that we're looking at, the Judicial Code of Conduct Act, has made provisions for a judge to recuse himself. Now, I know for some of us, we may have been listening about this word, recuse, for the first time when former President Lungu decided to bring that application before the Constitutional Court, requesting that the three judges, Justice Munalula, Justice Shilimi, Justice Mapanu, that they recuse themselves. That is a term that we shall basically be looking at. When a judge, when the impartiality of a judge is not guaranteed, when the impartiality of a judge is not guaranteed, the law that we are actually looking at right now demands that a judge must recuse himself when one of the parties to the matter demands it so. And it is very clear, as we shall see, that the judge ought not to debate the matter. The judge ought not to actually debate the matter, to say, no, I do not think my ability to be impartial in this case is going to be hampered or hindered in any way. No. According to the law, as you shall see it, members, when a party to a matter raises an issue bordering on impartiality and requiring that a judge recuses him or herself, the judge is not at liberty to start interrogating his own ability to be impartial or otherwise. There's no provision for that. So we shall look at all those things. So section number 3 is telling us about impartiality of the judicature in accordance with this constitution or with the constitution, this act, or any other law. Officer not to discriminate. Section 4, subsection 1. A judicial officer shall perform the duties of that office without bias or prejudice, and shall not, in the performance of adjudicative duty, be by word or conduct, shall not by word or conduct, as they perform their adjudicative duties, they shall not by word or by conduct manifest bias rather, discrimination or prejudice, including but not limited to bias or prejudice based upon race, tribe, sex, place of origin, marital status, political opinion, color, or creed, and shall not permit any member of staff or any other person subject to the officer's direction and control to so discriminate or manifest bias or prejudice. Subsection 2. Subject to subsection 3, a judicial officer shall not allow a legal practitioner or other officer of a court in any proceedings before the judicial officer to manifest by word or conduct bias, discrimination, or prejudice contrary to the Constitution or any other law against any party, witness, or any other person. Now, this, members, is a duty, particularly these two here. This is a duty that is being imposed on a judge. This is a duty that is being imposed on a judge. As a judge executes his or her adjudicative functions, these are first and foremost what must guide them. If the integrity of a judicature is going to be upheld, these principles that are outlined in subsection 4 are cardinal. But not only these, let us go further down. Discharge of duties, section 5. Section 5 says, subject to section 6. Now, I do hope, and I know by now we do know, that when a term says subject to, it simply means that it must be read together with that to which it is subject. And now I know, we now know that. Where any provision of an act says subject to, what basically it is telling us is that it can't be read on its own. For it to make sense, indeed, it must be read together with that to which it is subject. So here we are being taught, members, excuse me, we are being told that subject to section 6, a judicial officer shall hear and determine any matter assigned to the officer, except, now listen to this, except a matter which the officer is by law not competent to hear or determine. Now, some interesting terms have come in here. Subject to section 6. A judicial officer shall hear and determine any matter. So in short, it's the jurisdiction now that is being given. However, to this jurisdiction that is being given to a judicial officer, we are being told that there are exceptions. The exception here comes in where these clauses, as we shall see, provide, except a matter which the officer is by law not competent to hear or determine. So when we speak about competence, we're not talking about qualifications, no. Members, when we talk about competence, we're not talking about qualifications, no. So what determines competence, you shall see, is provided for now in another section. So the competence is not to say he's incompetent because he has no qualifications, no. When you speak about competence, we are saying that there are provisions in the law that bar a person from, in fact, adjudicating. That is why it is saying subject to section 6. So whatever it is that is the exception to what is in section 5 is to be found in section 6. But let's read further in subsection 2 of section 5. Let us read further subsection 2 of section 5. Subsection 2 of section 5 says, a judicial officer shall not, in the performance of adjudicative duties, be influenced by a partisan interests, public clamor, or fear of criticism. Partisan interest. Now, I'll say something about partisan interest soon. B, family, personal, social, political, or other interests. Or C, any other circumstances otherwise than that provided by law. So, as a judge now, in the performance of your functions pursuant to section 5, which has given you jurisdiction to determine any matter, to hear and determine any matter, there are what guides you, principles. There are principles that guide you. Some of the principles, not some, in fact, some are here. You ought not to be influenced by public interest, public clamor, fear of criticism, family, personal, social, political, or otherwise, or other interests, any other circumstances otherwise than that provided by law. This is so general. This is so general that, you know, it would have to be defined together with what is contained in gross misconduct under Article 266 of the Constitution. Clause 3, a judicial officer shall not use the office or the officer's position to advance any private interest of that officer, the officer's spouse, child, relation, or other person, or make any person believe that the officer's spouse, child, relation, or other person is in a position to influence the officer in any manner. 4, a judicial officer shall not testify as a character witness before a court. Before a court, you are a judicial officer. You are the one who is adjudicating. You look at a witness or a party to a murder case, and this person to you looks so scruffy, and you say, from there you deduce that this person, the way they look, most likely they should be the one that may have committed that murder. That is why we say justice is blind. That is why Lady Justice is always blindfolded. Lady Justice doesn't see, does not determine matters with her eyes. Lady Justice basically determines matters with their ears. They hear evidence. They hear submissions on the evidence. And based on the submissions and the evidence before them, they then arrive at a decision. Now, disqualification. This is where I said subject to. So, Section 5 gives a judicial officer the power to hear and determine any matter that is assigned to them. Give them the power to hear and determine any matter that is assigned to them. Now, there is an exception to section 5. It says, except a matter which the officer is by law not competent to hear or determine. So what are these now? Competences or incompetence. What would make a judge or a judicial officer to be incompetent in the language of the act? Not to be competent to hear a matter. That, members, is what now section 6 is talking about. So let's look at what section 6 is saying. Section 6 is saying, notwithstanding section 7. Now, again, so there are all these terms, members, that we are having to learn. Of course, others of us here already know what these terms mean. Others are basically having to confront these terms, if I may use the term, for the very first time. So first one is telling us about subject to. The other one is saying notwithstanding. Section 5 is saying subject to section 6. Section 6 is saying notwithstanding. So what it means is this, that section 5 shall make sense only when you read section 6. Section 5 will only make sense when you read section 6. And then section 6 is to be interpreted in the context of section 7, meaning what is in section 7 will override. That is what it means, members. What is in section 7 overrides what is in section 6, meaning section 7 takes preeminence over that which is in it covers and sits on top of, so that you stop seeing section 6 where section 5 is in place. Where section 5 is in place with regard to section 6, then section 6 will take effect. Where section 6 takes effect and the judge does what section 6 says a judge should do, that which a judge does, where section 7 comes in, shall override that which section 7, which section 6 rather says a judge shall do. So section 7 or section 6 together with section 7 is saying that even if a judge does that which is expected of him to be done under section 6, and the counsel, the parties to the matter, acquiesce to a judge proceeding, notwithstanding the issues of interest that may be raised, it will not matter. What shall matter is that which is in section number 7, as we shall be looking at. Let's look at section 6. So section 6 says disqualification from adjudication. This is what section 5, members, this is what section 5 meant when it talked about competent to hear or determine. So section 6 now, when it says disqualifying, it simply means that you are not competent to hear or determine this matter. It is not competence as I spoke about earlier with regard, or which is determined by the qualification that someone may have. No, that is not the competence that we are talking about here. When we speak about competent, we are saying it is the competence that is determined by the provisions of section 6, subsection 1, 2 of the Act. So let us look at section 6. Section 6 now is talking about disqualification from adjudication, whereas section 5 says a judicial officer shall hear and determine any matter that is basically any matter that is assigned to them. Any matter, with exception of that. Now, the exception is that which is now provided for in section 6. So section 6, subsection 1 reads as follows. It says, notwithstanding section 7. Now, the term notwithstanding means regardless of. That is what section that is what section 6, the term notwithstanding means. Notwithstanding simply means regardless of. So notwithstanding section 7. So Section 7 has made a provision that seemed to suggest that that which is in Section 5, that which is in Section 7, that which is in Section 6 rather. That is what is Section 7 about. Section 7 is suggesting that that which is in Section 6 must be disregarded. What must be followed is that which is in me, Section 7. Notwithstanding Section 7, what is in Section 7 ought not be considered. What must be considered is that which is in section number 6. That is what it means there. I just twisted things there. So notwithstanding Section 7, what we are being told is that whatever Section 7 is talking about must not be considered. What must be considered is that which is contained in section number 6. So notwithstanding Section 7, a judicial officer shall not adjudicate on or take part in any consideration or discussion of any matter in which the officer or the officer's spouse has any personal, legal, or pecuniary interest, whether directly or indirectly. So what we see in Section 6 is talking about officers, the officer or the spouse having a pecuniary interest, whether directly or indirectly. Of course, somebody may be wondering what it means by pecuniary. It means a financial interest. Notwithstanding Section 7, a judicial officer shall not adjudicate on or take part in any consideration or discussion of any matter in which the judicial officer or the officer's spouse has any personal, legal, or pecuniary interest, whether directly or indirectly. Subsection 2. A judicial officer shall not adjudicate or take part in any consideration or discussion of any proceedings in which the officer's impartiality might reasonably be questioned on the grounds that A, the legal officer has a personal bias or prejudice concerning a party or a party's legal practitioner, or personal knowledge or the facts concerning the proceedings. B, the officer serves as a legal practitioner in the matter. C, a legal practitioner with whom the officer previously practiced law or served. Or, let me just let someone in here. A legal officer practiced law or served. Or served is handling the matter. D, the officer has been a material witness. The officer has been a material witness concerning the matter or a party to the proceedings. E, the officer individually or as a trustee, or the officer's spouse, parents, or child, or any other member of the officer's family has a pecuniary interest in the subject matter or has any other interest that could substantially affect the proceedings, or F, a person related to the officer or the spouse of the officer. One is a party to the proceeding or an officer, director, or a trustee of a party. 2 is acting as a legal practitioner in the proceedings. 3 has any interest that could interfere with a fair trial or hearing. Or 4 is to the officer's knowledge likely to be a material witness in the proceeding. Now, members, when you look at what we have just highlighted here, it will tell you that you as a judge, when you see, not in fact, it will tell you, that is what this is telling us. This is the law. The law is saying that you as a judge, when any one of these things that are contained in section 6 are a possibility, means that you are not competent to sit or to hear and determine a matter where these circumstances basically exist. That is what the law, members, is telling us here. If any one of the circumstances that we have just seen here exist, this is the exception that section number 5 is basically talking about with regard to the competence of a judicial officer having to hear and determine a matter. We are being told that, let's go to section 5. Section 5 says, subject to section 6, a judicial officer shall hear and determine any matter assigned to the officer, except, so these are the exceptions, except a matter which the officer is by law not competent to hear. So what is this that determines competence? What determines competence are these things that are contained in section 6. The things that we see contained in section 6. These are the things, members, that will make a judge not to have the competence to hear a matter. That is why it is saying here. That is why here it is saying disqualification from what? Adjudication. So if any one of these 3 things, or 1, 2, 3, 4, 5, all the way up to 6, if any one of these 6 things, members, are likely to happen, and you are aware of that as a judge, you are supposed to recuse yourself. No one should ask you to recuse yourself. No. You are supposed to recuse yourself. Let's read further. Let's go down. So, waiver of disqualification. Now remember what section 6 is saying. Section 6 is saying, notwithstanding section 7. Meaning, even though section 7 is talking about waiving this disqualification by the judicial officer, bringing it to the attention of the parties that one of these things that are contained in section 6 may actually be present, and the party is saying it is fine. We do not think that you are going to be somehow swayed by these factors. We are told that even where the judicial officer brings it to the attention of the parties, and the parties think it is fine for the judicial officer to carry on hearing and determining the matter, eventually, if the judicial officer makes a decision and the decision goes in favor of one party and the other party feels aggrieved and the other party thinks that perhaps the judicial officer may have been influenced, it does not matter that the judicial officer had reviewed and that the parties waived that interest that the judicial officer might have. That in itself, members, may work as an appeal. The fact that the judicial officer went contrary to the provisions of section 6 and decided to hear and determine a matter, regardless of whether the judicial officer brought it to the attention of the parties and the parties agreed that the judicial officer should carry on with hearing the matter. What we are being told here is that if a party is not satisfied, it does not matter that the evidence may have weighed against them. Just the fact that the judicial officer might have had some interest or was disqualified pursuant to Section 6. It will not matter that they did not act in any way biased or in any way that would suggest that somehow, they acted with influence contrary to what is contained in Section 6. Doesn't matter. So they would not even have acted in any way influenced by what is prohibiting them in Section 6. And it would not matter that they did waive, the parties waived that requirement for the judge or judicial officer to recuse him or herself. The moment it is established that there was somehow some potential for the judge to act contrary to Section 6, that itself is enough for an appeal. Even where the matter might not have been influenced in any way, that members will be enough for an appeal, as we shall look at one case that was determined in the courts of law in 1889. Let's look at Section 7. Section 7, subsection 1 says, a judicial officer disqualified under Section 6 shall, at the commencement of the proceedings or consideration of the matter, disclose the legal officer's disqualification and shall request the parties or the legal parties or the parties' legal representatives rather to consider, in the absence of the officer, whether or not to waive the disqualification. Subsection 2. Where a judicial officer has disclosed an interest other than personal bias or prejudice concerning a party to the proceedings, the parties and the legal representatives may agree that the officer adjudicates on the matter. Subsection 3. A disclosure or an agreement made under subsection 2 shall form part of the record of the proceedings in which it is made. So when you look at this, this is obsolete. I'm sure you do understand why I say this is obsolete. This is obsolete because of this. What is contained in Section 7, members, is obsolete because of what is contained in Section 1, the first part of Section 6, subsection 1. Section 6, subsection 1 says, notwithstanding Section 7. So what is contained in Section 7 is the waiver. So when you look at this, then you ask yourself, so currently, what is transpiring in the country? We have a party to one's eligibility to contest elections in 2026 arising from a decision that was made sometime in 2017, sometime in 2018, sometime in 2019, all the way up to 2021. And decisions were made. Years down the line, a matter is reopened. 3 judges of the 7, or rather of the 5, that determine that matter have been suspended on the basis that their decisions were not okay, allegedly because they favored one side. That is what judges do, by the way. You are swayed by the parties making submissions, and you make your decision based on who has submitted persuasive evidence and submissions. So the three judges were suspended. We're not so much interested in the three judges. We are interested so much in the judges that remained. We are so much interested in the judges that remained. Now, the judges that remained, of the three judges that remained, two are newly appointed judges. One was part of the judges that made the determination that the former president was eligible, although in her ruling she dissented. And one would only, of course, assume that the reason why she had not been suspended, of course, could be because of her dissenting view to say the former president was not eligible. So she's not suspended, therefore she's part of now the Constitutional Court judges that are going to be hearing this matter that has again been brought to the Constitutional Court. So there is her and there is two more. Now the two, the former president had written petitioning the Constitutional Court that the three judges recuse themselves, because according to him, the one judge that was part of the judges that heard the matter and ruled that he was not eligible, he is contending that she should have been removed as well. She should have been suspended because she's part of the judges that determined in the matter earlier that he was qualified. So he is contending that there is a bias already because it is already predetermined what conclusion she's going to arrive at. And therefore, the petitioner is arguing that he does not expect justice to be served from her, because it is already known what outcome is going to come from her. That is one point. The other now is about the two judges. The two judges, he is contending that because there is a close proximity between the two judges and the incumbent president, who basically the outcome of the decision from the petitioner, former president, if the decision is to be made by the two judges, he is contending that it will be made to favor the incumbent, because in the previous petition, it was the incumbent, especially all those that were in support of the incumbent, that brought the application. So he is contending that the other two judges have a close proximity to the incumbent, to the extent that the chances of them being biased against the petitioner in favor of the incumbent are very high. So that is why he has asked that they recuse themselves. Now, recusing is not, as we said earlier, recusing is not a matter for the person, for the judicial officer who is being said to be biased, to debate and to argue on and say, I do not think I'll be biased. According to what we are seeing in section 6, section 6 is saying that you are not competent to hear a matter or to determine in a matter if any one of these factors here, remember, that is what we're being told. If any one of these factors here are basically likely to do what? To be there. So it is not now for me, a judge, who is being said or who is being told that I should recuse myself because by my presence on the bench is contrary to the provisions of section 6, subsection 2 of the Judicial Code of Conduct Act. It is not for me to say, no, I do not think my sitting is going to prejudice. That is not what section 6 of the Judicial Code of Conduct Act is saying. Okay, let us proceed on. So that is section 7, where a judicial officer has disclosed an interest other than personal bias or prejudice concerning a party to the proceedings. The parties and the legal representatives may agree that the officer adjudicates on the matter. Non-disclosure to members of public. A judicial officer or a member of staff shall not, while proceedings are pending or impending in any court, make any public comment. This is what is known as the sub judice rule. This is what members will refer to as the sub judice rule. You are not to comment. You are not to comment, be it a judge or otherwise. You are barred from commenting on any matter that is proceeding in the courts of law. So, members, when we speak about Judicial Code of Conduct, we are mainly talking about these 4 sections. Section 3, 4, 5, 6, 7. In fact, 5 sections. We are mainly talking about these 5 sections of a judicial code of Conduct Act. These are the 5 sections that mainly we are basically talking about. Now, unless there are questions here, I would like to proceed on and we look at, I would like to proceed on and okay, Angel, come in, Angel.
Yes, sir. Good morning.
Angel, how are you today?
I'm okay, sir. I just want to make a comment.
Yes, Angel.
I think the entire biasness or the refusal to recuse oneself is because of Article 140, to which those judges are appointed by the higher authority. So, and being having interest might not be an issue of question. It is because those who are employed them, who had put them there, they have to protect them. Or even if the law is saying the opposite, that they must not be biased and they must work in a fair manner. And the other issue that I want to comment on is from the previous proceedings, I heard that the CONCORT acted in incuria in the previous 3 judgments which were passed over the matter, which the court was ignorant of some issues which they passed 3 times. So I don't know if this issue stands saying in incuria, the court acted in incuria, it was ignorant of some clauses or some sections of the law, then the judgment might be reversed. I end my submission, sir.
Thank you very much, Angel. So the term is per incuriam. Huh? The term is per incuriam. When it is said that a judge or that the court has acted per incuriam, means that they have somehow disregarded certain provisions of law, either in statute or precedent. Remember that judges are always guided, just like you and I are. The judges are always guided by authority. There are two forms of authority that guide judges. First, it is statutory authority, and secondly, it is precedent. So when precedents are saying this, and yet judges say this, and what they say, which is contrary to precedent, is completely illogical to the precedent, that is what causes an appeal. That is what brings about appeals in the proceedings in the courts of law. So here, what we are seeing from what we are heard from Angel is that there are contentions that the constitutional court at the first instance had acted per or made the decision they made per incuriam. Now, of course, we are yet to hear the submissions, and see where the per incuriam came from, and then from there we shall be able to determine. But Angel also made reference to article number 140, which I am sharing on the screen right now. Perhaps, Angel, you'd like to say something about article 140. What were you saying again, Angel? Just say what you are saying again, please.
About 140, I said, since those judges are appointed by the president, the biasness is not far away from them in this matter. No wonder they had to refuse to recuse themselves when they were asked to recuse themselves due to the proximity they have with the other party which is interested in the matter. So I think these appointments maybe, which is not possible, although I would wish that the judges would be appointed differently and be removed differently from the bench, unlike the appointing officer through the submission of the judicial the commission, they are removed. So maybe there must be another way of appointing judges and another different way of removing judges, so that the executive does not influence the decisions of the judiciary. I end my submission.
All right. Yeah. All right. So we hear what Angel has submitted here. So Angel is saying the reason most likely why they are not recusing themselves is because of probably the close proximity, the close proximity that is there, where it could be, that, they are basically appointed by the president, they are appointed by the president, and because they are appointed by the president, they are actually acting in the interest of the president. So that is wrong. That is the correct submission you have made, Angel. There is a possibility, but that is wrong. That judges should owe allegiance to an appointing president. Because remember, Angel, that judges are not like politicians. Judges will stay in office years after the person that appointed them has left office. And the one that comes should not interfere with these judges to start appointing those that he equally or she equally thinks now should be appointed by that person. Judges are supposed to be politically neutral. Let me give an example. And on the aspect of bias, let me give an example of Chief Justice Robert Gates. Chief Justice Robert Gates, the Chief Justice of the Federal Supreme Court of the United States of America. It was sometime in 2011, just before the re-election of Barack Obama in the United States of America. The Republican Party had initiated legal proceedings against the Affordable Health Care Act, popularly known as the Obamacare Act. They didn't like it. Nice as it may be, they didn't like it because it was coming from a Democrat. Now, the matter was challenged in the Federal Supreme Court of the United States of America. And that court, by the way, is made up of 9 judges. It's made up of 9 judges. Of those 9 judges, the current Chief Justice, Robert Gates, is an appointee of George Bush, a Republican, when he was elected in 2001. He appointed President Robert Gates to be the Chief Justice of the United States of America. Now, when the matter, of Obamacare Act came before the federal court, 8 judges were torn apart. 4 were in favor of the petition by the Republicans. 4 were basically against the petition by the Republicans. And therefore, there was a tie. It was left to one person, which is the Chief Justice of the United States of America, to break the tie. And his lordship, Mr. Justice Robert Gates, the Chief Justice of the United States of America, he's the current Chief Justice, by the way, he ruled in favor of the Obamacare Act, which was passed by a Democrat president. Robert Gates himself was appointed by a Republican president. That is the judiciary. That is how the judiciary ought to operate. The judiciary is supposed to look at the law. It does not matter who appointed you as a judge. What matters basically is that you have been appointed. The job and the task, the responsibility that you have is to dispense with justice with your eyes blindfolded. You do not need to pay attention to who appointed you. If the person that appointed you appears before you as one of the parties, it should not move you. It shouldn't faze you at all. You are, if they are guilty, you are to find them guilty in the same manner you would find another person guilty. That would be brought before you. So I understand what Angel said. Sometimes judges think they owe allegiance to the appointing authority, but they are not at all required, because the Constitution, remember, requires judges to be independent. Section 3 of the Judicial Code of Conduct Act places those 3 principles as the core values through which the institution of the judiciary must operate. 1, upholding integrity of the judiciary. 2, upholding the independence of the judiciary. 3, upholding the impartiality of the judiciary. So it doesn't matter really who appoints me to the bench. If the person that appointed me to the bench is in the wrong, I should, in fact, adjudicate in a manner I would if any other person was the party to the matter. I should not be swayed whatsoever because of the fact that the appointing authority is one of the parties to the matter. So yes, unfortunately, there is that feeling, especially, you know, in developing democracies, where even the appointing authority feels and thinks that the people, the judges they are appointing should be toiling party lines. Judges ought not to toe party lines, no. Judges are umpires of justice. The opposition should run to the judiciary when they have been aggrieved by the party in government, and vice versa. Only then will there be confidence in the justice system by the general public. Otherwise, like we have been saying, the general public then will take the law into their own hands, not trusting the people who are in fact supposed to dispense with justice. Okay, let us quickly look at something else now. Let us look at case law. I want us to look at 2 cases. I'm going to give them to you because of time. I'll give them to you. I would love for us to finish our syllabus latest next week, Monday. Latest next week, Monday. I would love us to finish our syllabus so that we just remain revising and revising and revising for the exam. So let us just quickly, let me give you a case. It is, of course, in constitution, government, sorry, not constitution, it is in administrative law and process cases and commentaries. Let me just bring it on the screen. Let me just bring it on the screen. So here we look at the case of Gimes versus Grand Junction Canal. It's a case of 1889, or is it 1898? Let's look at that. The case of Gimes, D-I-M-E-S, Gimes versus Grand Junction Canal. This case, members, involved the Lord Chief Justice Cottenham, who was a shareholder in the canal company. He was a shareholder in this canal company, but at the same time, he was part of the adjudicators that adjudicated in this matter where Gimes had brought an action against Grand Junction Canal. The matter went in favor of Grand Junction Canal, but there was no evidence to suggest that Lord Cottenham, the Lord Chief Justice Cottenham, was swayed by biasness in the matter. There was no evidence to that effect. However, the court said on appeal, the court said that justice must be, or rather that judges must be seen to be, must not only be independent, but must also be seen to be independent. And it does not really matter. The court said it does not really matter whether or not a judge acted in a biased manner, as long as a judge, you know, may have somehow a connection to one of the parties to the proceedings, that judge must recuse him or herself, must not be allowed to sit and hear a matter where there could be some compromise in terms of biasness. So the case of Gimes versus Grand Junction Canal there, it's a case of 18. Let's see, what's number 158. 1852. I was not right on any one of the two options that I thought. So a case of 1852, members. I want you to go and read this case in its entirety. When we meet next week, Monday, we shall come and discuss it. So there is this case here, Gimes versus Grand Junction Canal. Then there is also the Nigerian case of Nestelo Gateway Group versus Al-Haji Abdulaziz Abubakar Yari. We go and look at this case as well. And on Monday, we shall come and have a discussion on this. And after that, we shall finish on Judicial Code of Conduct Act, and we shall begin on the Office of Ombudsman, also known as the Public Protector's Office. So members, that is about the Judicial Code of Conduct. That is about the Judicial Code of Conduct. We end here, and we shall see you and speak with you again on Monday next week. But of course, those that have questions, please feel free to raise your hands and to ask those questions. Yeah. If anyone has a question, please be at liberty to ask those questions, and we will be very happy to respond to them. Any questions, members? No questions. Okay, there are no questions. If there are no questions, then we have come to the end of our lecture for today. Next class will be on Monday next week. It will be the last class. After that, most likely, perhaps not the last class, but most likely the last class, so that after that, we shall then simply be doing our revision. We shall look at some past papers just so that we learn how questions are actually asked during exam in administrative law. So we end here, and we shall see you again on Monday next week.